Ebushon for Ahaye GC News, Mima Obibia Akwaba. Ahadie latest and hot news and Eramede Bremo. Anuti so subscribe to channel area, Bomodia say or best subscribe. You be say over click the subscribe button. Now what barely notification, you know. We understand the video be upload, you know. When the first person I was Ebeka ASA video. I feel we are now like a video and give us a thumbs up. Nafi share my Ato Forson when you be here now who and someone ekoso ewo Ghana memoir. I feel yembura aye and someone abeto yep no so yiti ayes a report here about to jai sanseme ekoso yiti.
Surrounding Parliament appears to have spiraled in what we are seeing today, perhaps in a show of power. Do you agree?
You see, in Parliament, parliamentary language is of the essence. And MPs have a way of communicating and conveying their sentiments, you know, to the electorate. Because they are politicians. And the way their constituents will understand them is how they will go about the communication. For me, it is not an instance of a show of power as such, but it borders on immaturity, inexperience, and a lack of common sense.
On whose part?
On the part of leadership of the House.
Okay.
When the speaker, when the whole controversy started on October 15th, some of us were able to predict what happened today as, you know, what was most likely to happen. Now, the one side is claiming to be the majority caucus, another side minority caucus, or vice versa. The speaker took the opportunity to explain how we got there. You know, because usually the parliamentary language has not been minority caucus or majority caucus. It's either the majority or the minority. Once you have a hung parliament, you know, some of these things are bound, you know, to occur. Now, when they do occur, the approach to resolving the issues is what matters, right, not the language. Like the unfortunate, you know, language of Afenyo Markin, the Honorable Afenyo Markin, in attacking the speaker, you know, was unparliamentary, very uncultured. You know, and this is the first time that I'm seeing live an MP attack the Speaker of Parliament using unparliamentary language, using invectives, using assaulting, you know, the Speaker's character, and, you know, playing to the gallery. It's unwarranted. It's uncalled for. And I'm glad that the Honorable Afenyo Markin himself recognized the need for decency. Now, a majority leader ought not launch an assault on the citadel of Parliament merely because they disagree with the Speaker. When he was addressing the media, the whole world was watching. This is not, you know, the way a leader, the majority leader, should address the Right Honorable Speaker. And I think that the majority leader or minority leader should apologize to the whole nation, not even to the Speaker, to the nation, because what he has done will forever remain a scar on the conscience, you know, of the nation. This is the first time that I'm seeing, you know, such an unruly behavior on the part of, you know, a majority leader. A majority leader carries the whole nation. They become the conscience of the majority with the people, the representatives. And therefore, if there is a matter, a burning issue in Parliament that requires maturity, the wisdom of the elderly, grey-haired people to purchase men's opinion, that is what, ought to be done. Not to, play to the guy by attacking the speaker, calling the speaker all sorts of names and saying that he's wreaking havoc on the nation. No speaker will, wreak havoc on his own nation. What for? You see, now, viewers will recall, with the greatest respect, it was not the speakers, whether it was a ruling or an opinion or a communication, that sparked of the fire. It was the announcement or the pronouncement of the NPP Caucus that they will boycott Parliament until the final determination of the suit before the Supreme Court. And the suit has not been finally disposed of. And therefore, as far as I'm concerned, they have said they will not go.
Right.
So let us wait until the 11th of this month.
But they asked the speaker to reconvene Parliament.
Yes, it was a laughable request they made. If you say that the Supreme Court has the most say in this matter, I beg to differ. The Supreme Court doesn't have any say in this political tussle that is going on between the minority.
Oh, you don't think it's a legal tussle?
No. It is devoid of any constitutional, legality, to send it to the Supreme Court.
Well, the Chief Justice thinks otherwise. She's been able to, find in the Constitution that even Parliament is subject to them. She went on to say not even the...
That has added to the problem.
The executive. How so?
Yeah, because you see, sometimes in trying to find a solution to a problem, you rather create more problems. Somebody runs to the Supreme Court. We have an issue in the Supreme Court. Who are the parties in the first place? So the Supreme Court, saw one party or recognized one party, Afenyo Markin. Who were the other parties? They said
the speaker.
The speaker. The speaker ought not have been a party. Under the Constitution, under Article 88, Clause 5 of the Constitution, the Attorney General is the nominal defendant. And since the Attorney General had not been served, there was no defendant properly before the Supreme Court. And that is why I have kept persistently to say that the jurisdiction of the Supreme Court had not been properly invoked because there was only one party. You need to tango. There must be two parties before the Supreme Court. Now, where the Constitution specifies a party, the Supreme Court ought to respect that. Where was the Attorney General? He had not been served. So the Attorney General didn't know. And if the Attorney General had not been served, he was not a party, in front of the Supreme Court.
But he was there, and I think he raised this, at the last hearing. He
Subsequently.
was there.
Subsequently. And that ought, to have preyed on their minds, should have weighed heavily on the judicial conscience and minds of the 5 justices of the Supreme Court. You see, now when they exercised, their discretion and assumed jurisdiction, they knew the consequences. Number 2, the Honorable Afenyo Markin himself has said that he went to the Supreme Court because he believed that a matter had arisen. So he required interpretation. Let us walk ourselves through Article 97, 1 up to H. Ask yourself specific questions. Take 97, 1A. Ask yourself, does it provoke or, call for interpretation? No. You go to B, no. You go to C, no. You go to D, no. You go to E, no. F, no. G, yes. How? When we are interpreting an act of parliament, it must be consistent, must be a consistent whole. You don't isolate. So if one up to G or H, make sure that the interpreting, will be wholesome. It will carry all the the substructures. Where you take one out of the lot, you miss the point.
And the Chief Justice at this point is missing that point.
They did, the whole court. The whole court. Because you say, I brought a copy of mine. It provides, it's clear. The language is, very, very, very clear. If you look at Article 97.1, 97.1, it says, it's on tenure of office of members. 97.1, a member of parliament shall vacate his seat in parliament. Shall vacate his seat in parliament, A, upon a dissolution of parliament. Does it call for any question of interpretation?
Well, the NPP Caucus leader in parliament thinks it does, and that's why the matter has gone there. But I want to pick up on something that you have said, that the Chief Justice and the panel of justices that have sat on this matter so far should have noticed that their jurisdiction was invoked incorrectly on the matter. We know that while the Chief Justice sat on this issue during the live coverage, she made mention of the fact that the vacation of an MP seat is heard by the High Court. The issue of whether or not the AG was a party to the case also came up, and whether or not, the Speaker should be a party to the case also came up. What I want to find out from you is the Supreme Court now, in your opinion, is the Supreme Court now fearing what could be its own inconsistency if it says that this matter, we were wrong about it?
I won't, say that the Supreme Court is fearing or, afraid of anything. I would rather put it this way, that, it was overzealous in an attempt to find a solution to a problem, a political problem. And the court cannot resolve. It is not the outcome of an election in which they will be closed or vested, with the requisite jurisdiction. This one, it is a communication that has taken place on the floor of Parliament. When that happens, it is something within Parliament. And if it is within Parliament, the long arm of the judiciary does not reach there. That is what we refer to as the political question. So, since the Tufo and Attorney General case in 1970, that has been the law, that if it is a political question, please just, fold your arms and ask them to go back and resolve the matter. But
I see. So will it then be your position, perhaps even admonition to the Supreme Court, that when they finally decide to give a ruling on the substantive matter before them, it should be one that unites Parliament?
The whole nation.
Ask them to take it away?
The whole nation, not only Parliament, not even Parliament. The whole nation. But you see, my sister, let's look at it, from another perspective. The majority leader rushes to Parliament. The minority is not there. The Attorney General is not there. Then the applicant himself says, Supreme Court, please, there's, a burning charcoal. We want, we don't know how to handle it, so you help us. So we need your assistance. Give us 10 days. We'll go back and sort out. You say no. The key word there in our law is shall, that where one party is absent, then if the court is minded to give a remedy in the interim, it shall not be for more than 10 days. The Supreme Court ought to have recognized it shouldn't be for, now it was indefinitely. It means finally, they have made a pronouncement. So when they go on the 11th, what judgment are they going to give? They pronounced upon it already.
I mean, it would also be an opportunity if indeed the Supreme Court has made a mistake, as you're saying, to undo the wrongs that they have done.
Oh, in Ghana? No. It won't happen. It won't happen.
Why so?
You see, the moment the whole nation descended on the Supreme Court, the next opportunity they had, if a court makes a mistake, it has an inherent power to correct that mistake. So it would have taken advantage to say that all of you are here. Now we made the order. On the spur of the moment, we thought, it was the wisest thing to do. But we now realize that we rather added to, the problem. So we are vacating the order and urging leadership of the House to go back and, find an amicable solution. That should have been the approach.
Right.
Now the Supreme Court has become, in the center of the controversy. So the Speaker says this. Now the majority leader has come to attack the Speaker publicly. Now, having attacked the Speaker, how is he hoping to go back to the same Speaker he has attacked to say, that let's go and talk? The Speaker will also attack him. That is why on the 18th, when I spoke on this issue, I said it was likely to create a situation of constitutional lawlessness in the country, and that is what we are seeing. And that
is exactly what we are seeing.
Yes.
The Speaker is worried about the precedents this could set, and he talks, perhaps not talk directly about it, but he's worried about what appears to be a collusion between the judiciary and the executive. What do you think about that?
That would be an unfortunate word, or expression, so to speak. I don't think that the judiciary will collude, with the executive. I mean, that will suggest that, they are in bed. The judiciary, is in bed with the executive. I don't think that is what is happening. What I believe has happened is that over the years, particularly the incumbent president has abused his position, his appointing powers under the Constitution. He's abused it.
How so?
He's abused it he's a lawyer. The president is a lawyer. And the president knows, as a lawyer, that the legal profession, seniority, is the key word. Seniority is the key word. And he has been an attorney general before. He's been involved, he's been president of the regional, bar. He's been involved in processes of, appointing justices, to the superior courts and other things. And he knows that, under the Constitution, under Article 144, Clause 6, if a vacancy occurs, there's a way, that it must be filled. Now, over the years, what, the current president has done, and I believe Mahama also did it, Rawlings did it, Kufuor also did it. The only exception is, in the case of Kufuor, when he recommended a justice, to fill the vacancy, because I happened, to be that person's friend, Justice Redu said, please, you serve the nation better, and it will be in the national interest if Aban were to continue. So he left it. Now, when Pega was sidestepped and his attention was drawn to the constitutional provision, he respected it. But currently, the present, situation is this: a vacancy occurs, and then the seniors are bypassed. Younger ones are appointed. when that happens, if I am a young justice, you know, of the Superior Court, and somebody far, my senior has been bypassed, when I get a nod, I will not work, you know, with my seniors. So I'll try to work with those who will be loyal to me. So this blind adherence to, you know, sidestepping the constitutional processes,
right,
and, you know, going to the bottom to pick, you know, from the layer, that is what is worrying us now.
Are you then saying that it creates an environment of justices, the Chief Justice, feeling indebted to the executive?
Sure, that's the word. Correct, yes. Forever and ever, I mean. And
they will tend to do things that appease
to the executive.
Or appeal to the executive.
Or let's say to the president. And I think that the time has come for some of us to give notice to whoever will be elected as the next president. We are not going to sit idly by and watch them, you know, sacrifice the Constitution to the dogs. We will not allow them to do that any longer. We have allowed Nana Addo, you know, far too many chances.
I see. So do you then see how the current constitution of the Supreme Court, and particularly, you know, those who are sitting on this case right now, there are those who feel that they have put themselves in the position for people to draw the conclusion that you're doing this in tandem with the executive?
I'll not say all five of them. I'll single out the Chief Justice. Her body language on that day, her body language was, you know, it was so what? I found that to be quite unfortunate, unsavory.
Maybe she was being assertive. You know, she needed to keep stern.
On the bench, we have the timorous souls and the bold spirits. You can be a bold spirit, you know, without manifesting, you know, that exuberance and, you know, emotional, you know, breakdown and those. If our loyalty and commitment must be to the Constitution, not to the president.
And you think if that loyalty was to the Constitution, we won't see the debacle we
saw? No. And that is why a former Chief Justice, her leadership, you know, Sophia Kufu, could say that we've been there before. We've seen it all. But this one, when we compare it with the previous one, this current crop of justices of the Supreme Court and the entire Supreme Court is all too predicting, all too predictable. The moment, okay, so Afenyo Markin, why did he rush in the first place to the Supreme Court? So the point is that all of us must endeavor, you know, to fight to protect and safeguard the Constitution. If the Constitution says that until a suitable person is found, the most senior must, any good leader should read that to mean the most senior must fill the vacancy. So if the words until provision is made, until a suitable person, if that is what is causing the problem, let us remove those words. Let us amend the Constitution, remove those words, and simply say that when a vacancy falls, the most senior justice of the Supreme Court shall.
I see.
That's all.
Very well. We're going to take a break. When we come back, we'll look into other issues. Don't go away. While we're on the subject of reviewing the Constitution, perhaps we could also look at 97, because the bigger picture then is if you look at people who talk about the history of why that was included to prevent cross-carpeting, then also we seem to be discouraging independent minds in Parliament. Perhaps we should review that as well, so that people can feel free and be with whichever group they plan to be with.
That's the more reason why it should not be reviewed. Because in the wisdom of the framers of the Constitution, cross-carpeting should be discouraged.
Why not? Why so? Why should I be punished because I no longer want to, align with
because the
party
you
A?
knew when you were seeking power, you thought that you could use a certain political structure as a springboard, isn't it? Mm-hmm. Now that you have the thing on your lap, you say, well, I think I made a mistake, so I want to defect, or I want to go back to this. So
does it not stifle independent thinking in that you are now expected to think alongside the party that brought you into Parliament all the time?
It is not stifling your independence. All that it is saying is, please be loyal to your constituents. Be loyal to... But
not the political party that brought you
there. To the party, to your constituents.
So the point I'm making is that you can't still serve your constituents, because your constituents are not only made up of party A. If we got rid of that, then a member of parliament of party A who no longer thinks that party A is serving his or her people will now choose to be an independent member of the House or be with party B, because party B's ideologies and beliefs in Parliament will serve his or her people.
Do you know why some vote skirt and blouse? Because they don't like this person, but they like the other one, and therefore I don't like you, I won't vote for you. I like him, I'll vote for him. Now, in the wisdom of the framers of the 1992 Constitution, it said, look, in order to discourage disloyalty, absenteeism, defection, crossing of carpet, whatever, once you enter, make sure that the 4-year lifespan, you commit and dedicate yourself, your soul, your mind, your body, your spirit, to it until after the expiration of... Now, if for any reason, because you see, under Article 1125, the point is, the 1125, the point is that 30 days, to elections, there can't be any, general election, so no by-election. Mm-hmm. Economic factor, you see. So 1126, because of that, if what you just said occurs, the Constitution says that you shall have vacated your seat. It is not the Speaker. It is not the Supreme Court. The Supreme Court has nothing, to do with it.
It's already stated.
Yes.
Is the NPP caucus leader leading his caucus astray?
From the letter I saw, of his, encounter with the media, I think he's been overwhelmed, with emotions and frustration. He believes that it is the Right Honorable Speaker, who is causing, problems for him. But I think that on this occasion, it is the NPP caucus that is, shooting itself wrongly in the foot. You walk out, you tell the whole nation you boycott until the final determination of the case, and the case has not been finally determined. Don't blame anybody. Blame yourself. It was not Honorable Bawumia who led them to boycott. He had nothing to do with it. They themselves said, so they made their bed. Let them lie in it until after the 11th, and then we see what happens.
Well, they plan to meet Speaker after the news conference to discuss the issue further. How do you think that could go?
Speaking as a Ghanaian, I think the Speaker will be very angry with them in the first place. And that is where maybe your description of the show of power, comes in. Now you have humiliated me, You vilified me, you know, full glare of the public. What do you want from me again? Are you going to undo what you did? So you go and apologize publicly, and then you can come back. I'll watch it. What if the speaker, you know, turns around to say that I'm going to the court, I'm suing you for some of the words that, you know, you use. Now, we don't even know the forum where, you know, the encounter took place. If it is parliament, you know, you have immunity. But if it is outside parliament, then that's another matter. So my take on the matter, you know, my appeal to the Right Honorable Speaker will be, you know, to show maturity, accept them. If they are coming back, he should accept them. It's like, you know, the biblical sheep that, you know, went, you know, to the wilderness, and if they are coming back, let them.
One thing we know for sure, the you know, the NPP Caucus plans to do is to cite the speaker for contempt. Under what circumstances could they do that?
Contempt, general contempt of parliament, you know, privileges, under Article 122, they have, you know, that power. But if the speaker is, you know, performing his constitutional role, under what, you know, circumstances can you cite him for, you know?
Well, for not ensuring that the status quo is reversed. The status quo of they being the majority side is reversed.
Yeah, but the caucus leader himself conceded. He said, you know, the speaker, so they went to check, to verify from the clerk, and the clerk, you know, confirmed, yes, I've been directed to do it, I did it. And how does the majority caucus leader know that the speaker endorsed the unruly behavior, if I may put it that way, of, you know, the few, you know, miscreants who did it? Because
he didn't ask the NDC caucus to move to his left side.
The people's grandfathers and grandmothers and uncles and fathers, how could, was he expecting, you know, the speaker to go there and say, schoolboys, you know, if you are okay you or not? No, it is up to the leadership of the house. It is not, you know, that's what the speaker is, a neutral person. He must always show neutrality.
I want to draw you back into the conversation around the case at the Supreme Court now. When the Supreme Court granted the injunction, I think the ex parte application, its reason, the backbone of its reason was because they thought that the people in the constituencies involved should not be deprived of their representation. Now, when you compare the Supreme Court's reason for its action to what we see today, and you know, an NPP caucus that will not sit in Parliament, but only wants to be crowned majority before it goes there, do you get the sense that perhaps this was not because of representation from the very beginning? It was because leadership didn't want to lose their slot in Parliament?
Sure, but that's the more reason why the Supreme Court should have been much more circumspect in you know, trying to handle the matter. Maybe, just maybe, what has happened, you know, might be a useful lesson the entire nation, and next time we should reflect. We should do some, you know, self-introspection before we take on certain tasks, you know, that we think we should do. The majority caucus is not demonstrating disciplined leadership. That is the bane of the NPP now. You know, leaders have come and gone, and the current leadership.
Well, but the NDC caucus could also decide that we won't sit here post the Supreme Court ruling. We would go to the left side where they usually sit. Why haven't they also done that?
Yeah, but you see, this is why I'm saying that it is for the leadership. This is not a matter, you know, that should engage the entire, attention and time of the nation.
I mean, that is curious as well, isn't
it? Yes, the NDC minority is not, also behaving, properly. It is misbehaving just as much as the NPP caucus is misbehaving. But if their leadership, if the leadership of the two caucuses were disciplined and up to scratch, this thing won't happen. I mean, when J.H. Mensah was majority leader, senior minister, there were many more, problems, bigger problems than what we are seeing today. He managed it well. When what is his name? The Swedru NPP. See, he also handled it. Why is it that this time around, both caucuses are unable? If you listen to what Kennedy Agyapong said, it shows, it gives room for, some comfort. He said, look, what has happened, instead of attacking the speaker, we should have apologized because the speaker was not aware.
Well, but he's one of the mature or experienced legislators. He stood behind the caucus leader when he was making those comments. He didn't differentiate at that point.
But if you look at the body language, and after they had finished, he also, spoke. So what I've just said, is taken from, the remarks. But
that also means that the mature heads that you expect to be involved in this are also just looking on in Parliament.
But he said, you heard him say that, I mean, he is not, in the leadership now. He made it quite plain. So it means some internal infighting. Because if the person said, well, this is what we should have done. But someone who said, me, I'm not part of the leadership. So it speaks volume.
That's what it tells you.
Yes.
That's what it tells you.
Yo, if you're waiting reporter, Abeto, yepono so. So when you subscribe to channel na bomodi say obe subscribe. Na fe wa like video, like the video. Na fe share ma Ato Forson na when you be here. Sanse hadie latest and hot news. And kwa Aremeyaw bremo. Also betimi otchere wadwin afa eye some way nyina ho ewo comment box ni mu. Mubeti minkabi in my next video.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.